Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. While it's true that the vast majority of personal injury cases resolve by way of a compromise settlement, it's not true of every case. Some cases still need to be tried in front of a jury in order to get a jury verdict. Well, a lot of people think that getting a jury verdict in a case is the end-all be-all of the case, the conclusion of the case, but that's not always true. In a lot of personal injury cases, there are a lot of things that happen even after a jury renders a verdict. So one of the first things that usually happens after a jury verdict is rendered is either one or both of the parties file a motion for new trial. In a motion for new trial, essentially each party files it, and essentially they would be saying that the judge made some sort of mistake or error in the conduct of the trial, and that error in the trial caused them to get some result less than what they wanted. In other words, it might be the plaintiff saying, well, we got less money because you ruled on this piece of evidence in this manner. Or it might be the defendant saying, well, the plaintiff won when they really should have lost because you let in a certain amount of evidence or a certain piece of evidence. So the parties will go to the judge and argue a motion for new trial in front of the judge, and most of the time, the judges feel like they did a pretty good job trying the case. And so a lot of times, or most of the time, a motion for a new trial will be denied. Once a motion for a new trial is denied, then the parties, whichever party feels like they're aggrieved, or sometimes it's both of them, can decide whether they want to file an appeal. And usually cases get appealed if there's been a drastic win or loss one way or the other. So an example might be if the plaintiff got a huge verdict of multiple millions of dollars on a case that the defense didn't think was worth that, then a lot of times the defense will file an appeal to see if they can get that verdict taken away. And likewise, the same if the plaintiff felt like he should have won the case, or even if he thought he was going to get a modest verdict, but the defense wins, if there is a defense verdict, then a lot of times the plaintiff will appeal in order to see if he can get a second crack at a trial. So see if he can get the appellate court to kick it back to the trial court for a retrial of the case. And so an appeal, but the thing about appeals is they're very expensive and they're time consuming. They usually add a year and a half or so to the length of it that a case drags on. So what the practical effect of motions for a new trial and appeals are is that it usually brings the parties back to the table. In fact, there's almost always another appellate mediation where the parties continue to haggle and continue to negotiate and to see if there's some resolution of the case that can be had that would be mutually acceptable to both parties. So when people think that they don't want to settle the case, they want their day in court, and that they're never going to have to compromise or negotiate at all with the other side again, that's really not true. Their negotiations typically go on throughout a case until it's finally concluded either by a settlement of the parties while it's up on appeal, or if the parties have enough patience to wait it out at the end of an appeal, because it will always go one way or the other. So a lot of people think cases are done when verdicts get rendered. It's not the case at all. So if you have any questions about Florida personal injury cases, jury trials, jury verdicts, what happens after a verdict, please reach out to us. We'd love to answer questions. All you have to do is call us at 407-254-4901. You can text us at 407-644-4444, or you can even reach us through the Facebook Messenger app.